Hey, everybody. I'm Rob Gunning. I'm the chair of the ADR section of the Boulder County Bar Association, and it's great everybody be here today for this fantastic panel presentation. I don't want to take up too much time because we have a great presentation here. Just want to note a few things on behalf of the ADR section. We're co-sponsoring this CLE today with the family law section and upcoming events. I just want to note that the ADR section will be highlighted in the upcoming Boulder County Bar Association newsletter for January. I'll be issuing a article on confidentiality of mediation communications based on the Tuscany Homes Court of Appeals decision from last year. We're also going to have bagels with the bar. The sections rotate sponsoring that event, and the ADR section will be sponsoring that event on March the 2nd of next year. And then we hope to have another CLE coming up sometime in the spring. And so those are some of the things that we have coming up. And without further ado, I'll turn it over here to Beth Orenstein, who's been instrumental in coordinating this panel presentation. And I really want to give a shout out to Beth for doing that and for coordinating this today.
Thanks, Rob. Welcome to today's program. I know most of you who are here in attendance, but I understand, some people may be joining us, and we have some people who are going to be doing this as home study. So welcome to this program wherever you may be and whenever you may be. Thanks to the ADR and family law sections for inviting Front Range Collaborative Divorce members to provide this update on collaborative law in Colorado. I'm a member of both sections and the FRCD, and I have the privilege of monitoring today's panel. Front Range Collaborative Divorce is a professional practice group consisting of collaboratively trained attorneys, financial professionals, coaches, mediators, and mental health professionals, as well as collaboratively trained associates who have experience in a variety of relevant areas, such as business valuation and real estate. We meet monthly to get to know each other, debrief cases, and learn from one another's experiences and skills. This is important to our ability to develop trust for one another and to work as teams in collaborative practice. We are not a legal entity, and we don't work together in a firm. FRDC is one of 6 practice groups in, sometimes I reverse these initials. It's FRCD, is one of 6 practice groups in the state associated with the statewide organization, Colorado Collaborative Divorce Professionals. CCDP encourages excellence in the practice of collaborative law through ongoing professional training. Websites for FRCD and CCDP are included in the PowerPoint that we'll provide to you after the presentation. I will also try to remember to put those websites in the chat so that you can see them and refer to them. The 4 panelists today will present a history of the development of collaborative divorce law in Colorado, information about the Uniform Collaborative Law Act, a description of the collaborative divorce process in Colorado, including benefits and when it's appropriate or not appropriate, a description of the roles of team members, a comparison of the collaborative divorce process to mediation, and information about how to obtain collaborative training. We're going to ask that you include your questions in the chat, and we will entertain questions and answers at the end of the presentation. So we will begin, but with me introducing each panelist by their role in the collaborative process, and each panelist will then tell you a little bit about themselves. We'll discuss the collaborative roles later in the presentation in more detail. So the first panelist that you'll be hearing from is Georgiana Scott, who is an attorney.
Thank you, Beth. I've been practicing family law in Colorado for 26 years. I started practicing collaboratively in 2004. I'm a founding member of FRCD, our Boulder practice group. I also serve on the board of directors for CCDP at this time.
Thanks, Georgiana. The next person you'll be hearing from is Amy Stengel, who is also an attorney.
Thanks, Beth. I'm Amy Stengel. I've been licensed as an attorney in Colorado since 2003, and I'm currently practicing as an attorney and as a mediator as well with Conscious Family Law in Boulder. I've been involved in collaborative practice since 2019, and I took the training in 2020.
Thanks. The next person we'll hear from is Patrick Jansen, who is a financial neutral.
Yes, good evening, everyone. Patrick Jansen. I am a certified divorce financial analyst and a financial advisor. I serve as a financial neutral in collaborative cases. I'm a former board member of Colorado Collaborative Divorce Professionals, and I've taught level 1 training. And I started back in 2012, not quite 20s or 2004 like Georgiana. So, but 10 years is a lot of experience, and I'm happy to be here with you tonight.
Thank you. Janine Lee is our next, will be the last person you'll hear from. You'll hear from everybody throughout the program, but Janine is a collaborative divorce facilitator.
Hi, everybody. Yes, collaborative divorce facilitator in this process. I've been involved in our Boulder practice group since 2008. I'm also trained as a mediator, conflict coach, relationship systems coach, and a grief recovery coach. And I am author of this book. I also help struggling couples explore staying together if they want to, and help parents better cooperate post-divorce.
And what is the name of your book, Janine?
Oh, sorry, I did it fast, didn't I? It's Beyond Divorce. Stop the pain, rekindle your happiness, and put purpose back in your life. And I won an award for it. I got to go to New York and get an award for it.
Congratulate you now.
Yeah, thanks.
Okay. So now Georgiana will begin the presentation with a history of the development of collaborative divorce law generally and in Colorado.
Thank you, Beth. We want to first emphasize that collaborative divorce process is an alternative dispute resolution process. Collaborative divorce was developed in 1990 by a Minnesota family law attorney. As of this month, 21 states and the District of Columbia have enacted the UCLA, the Uniform Collaborative Law Act, or adopted rules or combinations of statutes and rules enacting the UCLA. Currently, collaborative law is practiced in every state in the US, As of now, 24 countries internationally have developed collaborative organizations. And according to the International Academy of Collaborative Professionals, more than 22,000 attorneys have been trained worldwide in collaborative law. In Colorado, the first collaborative law training took place in 2001, and that's about when collaborative practice began in Colorado. The UCLA was first proposed for adoption in Colorado in 2011. Because most collaborative cases are started and resolved prior to filing the case, the UCLA's specific language assures participants and lawyers that the process will be confidential and privileged. One essential tenet of collaborative divorce is that the attorneys be disqualified should a collaborative process fail. Parties sign a specific contract called a participation agreement, which you received in your materials, in which the parties agree that their collaborative counsel will be disqualified in the event of a failure in the process. At that point, they also agree that they will avoid court intervention during the process. So in 2006, the Colorado CBA Ethics Committee issued Ethics Opinion number 115. Ethics Opinion number 115 created a lot of hubbub in the collaborative community, but essentially what it stated was that collaborative practice was ethical, except to the extent that lawyers signed the participation agreements in which they then contracted with an opposing party to be disqualified in the event that the process failed. So it happens that a footnote in the ethics opinion helped us resolve that situation. And essentially what's come up now is that attorneys simply don't sign the participation agreements any longer. However, the parties continue to contract that their attorneys will be disqualified if the process fails. The UCLA has now codified and satisfied the concerns of Ethics Opinion 115. I will say that the disqualification requirement is also an incentive for parties to remain in the process, primarily because the expense of changing counsel in the middle of the case is quite high. Ultimately, the UCLA was passed into law on May 17th, 2021, and takes effect January 1st, 2022. Amy's going to speak more in depth to the specific provisions of the UCLA in a moment. We want to just point out that the acceptance and evolution of collaborative law mirrors the evolution of mediation and other ADR processes that have occurred over the past 40 years in Colorado. Thank you.
Thanks, Georgina. Oh, let's see, I'm gonna. That's okay.
Yeah.
So thanks, Georgina. The UCLA is codified at Article 24, Title 13. Just a bit of background. It was originally drafted by the Uniform Law Commission in 2009 to address the lack of standards, lack of national standards in collaborative practice. The concern being that the lack of national standards created a lot of variance in the practice and increased the likelihood of a collaborative lawyer might unknowingly commit malpractice during the collaborative process. By having a standard national model, attorneys are better able to explain the limitations, the benefits, risks of the collaborative approach. So I've excerpted some key provisions of the UCLA. This isn't the act in its entirety, and I have condensed and paraphrased some of these provisions. So this is the 1324-103 is the definition section, and I think Colorado has chosen to limit collaborative law to the resolution of disputes in the family law context. Although states adopting the UCLA can determine to expand the use of collaborative law to other areas of practice, there's essentially two versions of the UCLA. Early in 2021, the bill sponsors in Colorado amended an earlier version of the bill in order to limit it to the application of the UCLA to family law. 104 addresses the minimum requirements for the collaborative law participation agreement that Georgina referenced. Namely, that it be agreement signed by the parties, that it reflect an intention by the parties to resolve a collaborative matter through the collaborative process under Article 24, and describe the nature and scope of the matter. And the agreement importantly confirms that the participants have been informed about the disqualification process, the consequences of the disqualification process. Did I go through that too quickly? Oh, wait a minute. I think sorry, I skipped one. 106 addresses, section 106 addresses circumstances in which a court can issue a stay of proceedings in order for a collaborative law process to move forward. So this is unlikely, I think Georgina mentioned, to really be applicable in that the majority of collaborative law cases begin and resolve prior to anything being filed with a court. But also a status report can be, this just clarifies that if, in the event that a court requires an update from the parties, a status report can be filed with the court, but cannot provide any kind of assessment or evaluation of the progress or of success of the parties in the collaborative process. Let's see. So 109 addresses the disqualification of a collaborative lawyer and lawyers associated in the law firm of the collaborative lawyer. So as Georgina mentioned, a collaborative lawyer is disqualified from appearing before a tribunal to represent a party in a proceeding related to a collaborative law matter. And the disqualification extends to lawyers in in the firm in which that lawyer is associated. There are two narrow exceptions to this qualification. One being that a collaborative lawyer can apply to the court to request approval of an agreement that's been that's resulted from the collaborative process, i.e. entering an appearance at the conclusion of the collaborative process to request approval of a separation agreement between the parties. And also a collaborative lawyer can request an emergency order from a court in the event there's a threat to the safety of a party or child related to that collaborative process. 112 addresses, just want to make sure that I'm right. Okay. The disclosure of information under the Act. Obviously, the voluntary disclosure of information is a central tenet of the collaborative process and allows the parties to build trust, which is, essential component prerequisite to being successful in the collaborative process. There isn't a way to compel disclosure. So if one party feels the other is acting in bad faith, is not making a full and accurate disclosure, the remedy would be to terminate the collaborative process, and so doesn't not apply to the court for any type of enforcement. (113) just clarifies that the professional responsibility, the rules of professional conduct aren't amended or affected by the UCLA, and extends this to obligations and standards of practice for the other licensed professionals that might be involved in a collaborative case. So 114 addresses the appropriateness of a collaborative process and informed consent to participants. The UCLA places specific obligations on a collaborative lawyer that need to be fulfilled prior to the participants entering into the agreement, namely a discussion of the factors supporting the appropriateness of a collaborative law model or collaborative law matter for resolution through the collaborative process, as well as a discussion of the risks and benefits of the collaborative law process relative to other forms of dispute resolution that might be available, including litigation, so that when the prospective client enters into a participation agreement, they're really informed as to the options that are available to them. And let's see, specifically 114 provides that the participants will be advised in writing that the collaborative matter will terminate if a party seeks intervention by a court, by a tribunal, that the participation in the process is entirely voluntary, and they have a right to terminate unilaterally with or without cause. And as well, that they've been advised that collaborative lawyer cannot appear to represent them in a proceeding related to the collaborative process, collaborative law matter. Let's see. Did I go too fast? I just want to make sure that I haven't skipped anything. 115 addresses the ongoing obligation of a collaborative lawyer to essentially assess for the existence of a coercive or violent relationship between the parties to the collaborative matter. This extends through the process, and in the event that a collaborative lawyer does determine that that a coercive or violent relationship exists, they may not continue or initiate the process until there's a reasonable belief that the party can be protected in the process. 116 addresses the confidentiality of collaborative communications. This is also obviously an essential piece of the statute. The communications are confidential to the extent agreed upon by the parties and is provided by law. Clarifies that nothing modifies the confidentiality provisions of Article 22. I think I went too fast. Let's. Section, let's see, what is it? Just hid my number, 117, sorry. Addresses the privilege. This section creates a broad evidentiary privilege for parties' communications in the process, and also extends that privilege to non-party participants in order to facilitate a resolution of the issues. A collaborative law communication privilege under this section is not subject to discovery. It's not admissible in any as evidence in any proceeding except for as specifically agreed upon by the parties. This collaborative process does not preclude disclosure of evidence or information that was disclosed pursuant to 16.2 that would be otherwise admissible. 118 just clarifies that the privilege can be waived upon, expressly waived by all the parties and participants. 119 sets out the specific exceptions to the grant of privilege for communications from the collaborative law process. There are standard exceptions pertaining to crime, commission of a crime, bodily harm, threat to the safety of a child, as well as communications that would be available under the Open Records Act. There's no privilege in this instance. Additionally, those communications are not privileged to the extent that they're being offered for to prove a claim of, or prove or defend a claim of misconduct or malpractice from a collaborative lawyer or expert involved in the case. Did I skip one? I think. Oh, okay. This is the last one I have. 120 addresses the authority of the tribunal and of a court in the event of non-compliance. So if an agreement fails to meet the requirements of the act, or an attorney fails to comply with the 114, which is the informed consent provision, or 115, which is the assessing obligation to assess for a coercive or violent relationship, a court can still find that the parties entered into a collaborative participation agreement if there's a signed record of intent to enter into an agreement, and a party reasonably believes that they were participating in the collaborative process. So once a court makes those findings, the court has the ability to, or tribunal has the ability to enforce an agreement resulting from the collaborative process, as well as apply disqualification provisions of the statute and permit a party to assert a privilege under 117. Okay, that's all I have for provisions of the statute.
Thanks, Amy. I think you can probably take this down, stop sharing for a moment.
Sorry, yeah, sorry. Yeah.
That's okay. And there's a lot packed into that presentation. We're going to move on a little now. Georgiana and Patrick are going to talk about some of the benefits of collaborative divorce.
Thanks, Beth. One important part of collaborative law is that it is a needs-based focus. In other words, instead of trying to get as much as one can get, the collaborative process is more concerned about the needs and goals of the spouses and their children. We want to note that collaborative process can also be appropriate for parties without children. The collaborative process allows an opportunity for increased client empowerment. The clients are equals with their attorneys and the other collaborative professionals. As Janine likes to say, the parties are in the front seat of the car with the attorneys. So you don't see situations where suddenly some discovery has been filed and the the party isn't quite understanding that that was either going to happen or has happened. Collaborative divorce also allows parties to take the high road. It allows them to be gracious and generous and empathetic toward their spouse's fears and needs. It also allows the parties to keep the children in the tops of their minds at all times in the process. And now for Patrick.
Yeah, so once upon a time, long before I knew anything about the divorce process or becoming a certified divorce financial analyst, I went through divorce personally. And this was a very amicable separation, what I think we call a kitchen table discussion. We reached financial resolution. Some time went by. I'm thinking this is going to be pretty smooth. And then I find out my wife at the time hired legal representation. And again, I knew nothing about the divorce process. So in my mind, I instantly became apprehensive, defensive, a lot of anxiety. Are we going to go to court? Do I need to hire someone in my corner to fight? What do I stand to lose? And knowing that the financial process with divorce, there's an outcome that never really feels that great. So I think one of the real special things with collaborative in my mind is that it diffuses that anxiety, and it diffuses the unknown. And it's principally because the attorneys, the way they work together, the working relationship that they have, that they do express interests and sensitivity for the other party's concerns and needs. And that's not to take away that each attorney, still is operating in their client's best interest. So not only does it affect, I think, the clients and the whole process and the way we communicate and how efficient the process flows, because I think emotionally we're more in check. And but it also helps the professional team operate in a much more cohesive and effective way. I know a lot of my cases fall outside of collaborative. And when I have highly litigious attorneys that are going back and forth, it's difficult to be as effective as I want to be in that type of situation. So I kind of call that the secret sauce of collaborative. I just love the way that the attorneys work together. And I think the clients, in fact, I know the clients appreciate that. Beth? All
right, thanks, Patrick.
You bet.
So we're going to move to Janine, and we can bring up the slide again. So Janine's going to talk about how the process works using the roadmap that we provide to clients. I don't know if Janine is muted, but.
I think she is.
Janine, you are on mute. Can't hear you.
Sorry. I was trying to be a good participant and be muted.
It happened to me before too, Janine. I was introducing Amy and nobody heard it. I did a great job.
Right, there we go. Okay, so the collaborative method or process offers a focused method of reaching resolution. And this roadmap, which by the way is copyrighted, lays out the process. Depending on the case, some of the steps may take longer than others, but as you will see, the sequence is intuitive and logical. So the first thing, we want to have clients understand and agree to the process. So there are a few key items that clients must understand in order to proceed with collaborative, and we will be presenting those throughout this presentation, so you'll get to see more of those. So right off, documents are signed. They're signed electronically, initiated by the attorneys with his or her client. And then at the first meeting, At the first meeting, we want to review key points of the process so that the clients understand it, because there's some things that are a little bit different than they might expect. So we want to make sure we hit the highlights with them, and then we answer any questions that the clients might pose. We also review with the clients the important ground rules, such as focus on the future, not on the past, focus on solving conflict, not on blame, avoid sarcasm, criticism, judgmental comments, interrupting, the usual stuff. And then, of course, having patience with the whole process and with themselves. And by reviewing these together, everyone knows what everyone knows. And so later, if the clients need reminding, then we can bring those up. They've already heard them and they're expecting them. And it helps rein in too. So the next thing we want to do is help the clients identify their interests and goals. This is the heart of the collaborative process. And by doing it in the group, the spouses get to hear each other's interests and goals, and both of the attorneys hear the interests and goals of the other client, which is important. Patrick just spoke to that a little bit. So some examples of interests and goals can be financial security, expectations around extended family, keeping children free from divorce-related conflict, things like health and spirituality, decisions for the children. They're very diverse and can be all over the map. They're as diverse as the couple themselves. So having these goals gives the entire 6-person team, which is the 4 professionals and the 2 clients, we consider the clients part of the team, gives us a point on the horizon to which we will shoot, and which we will compare any division scenarios against. So everybody knows what these are. There's also an opportunity to deal with interim issues. This allows us to immediately deal with things that might come up, like temporary parenting arrangements, temporary support, equal access to finances and children. There's different things that can come up, and this is provided for. I don't see it very often in the places I've been on, but it's there nonetheless should we need that. Then we come to gathering information. This is very important. Our financial neutral leads this, and Patrick's going to explain this in more detail coming up. So the remainder of this roadmap, numbers 5, 6, and 7, are handled as a team. The creative problem solving is one of the parts I love the most. Ideas can come from either of the clients. They can come from any member on the team, or it can be a combination of ideas. We make it clear that this is a time of brainstorming, so not to get attached to any one idea that's thrown out, especially if the other spouse throws out something you don't like. Don't get attached just yet. And then every scenario is tested against that point on the horizon, against the client's needs and goals. Which one is it that's going to best meet this couple's or family's needs going forward? That one is the one that gets developed into a final agreement. So throughout this process, the clients have taken the lead. They're often working with the neutrals, but here at the end, the lawyers then take over the lead in drafting the documents. So there it is in brief. You will have a copy of this in your slideshow presentation so you can follow it. Thanks, Beth.
Okay, thanks. I think we can take down the screen share for a moment. Right now we are moving to talk about the team approach, which is vital to the success in a collaborative divorce process. The team consists of the financial neutral, a collaborative divorce facilitator, and the attorney for each client, as well as the clients. Although it's not always possible, we do try to have a gender balance on the teams. And people may wonder how you get into collaborative, how people find out about it. Well, any of the professionals can be the initial contact for the clients. So we'll start out learning more about the role of a financial neutral. Patrick.
Yes, so do we have the slide?
I think Amy's getting it ready.
Amy's getting it, okay. Otherwise, I'll bring it up.
Okay, so I actually think can you bring that one up, Patrick? Because I think that one got taken out of this version. Sorry about that. I thought it was.
No worries.
Oh, but we do have something else I think Janine wanted to talk about, maybe.
Sure. I think we're here, right? Isn't this?
Yeah.
Yes.
So, okay. Yeah, so I think of my role in collaborative in three unique and distinct areas. And I've listed the three right here: financial discovery and disclosure, which is really to provide transparency to not just the clients, but also what I feel is my other client, which is the attorneys and the facilitator. There's a financial education component, and there's a financial modeling component. So starting with financial discovery, we all know 16.2, so there's a lot of administrative work, gathering documents, putting them in a logical file in Dropbox, making sure I've collected all of the marital and separate property. I'll create a balance sheet or a property statement. I'm also asking the clients to look forward a little bit post-decree, because I'd like to understand what the estimated living lifestyle expenses might look like. Now, why would I want to do that? I want to evaluate, based on certain financial settlement options, what each of their financial futures might look like from a cash flow, from a retirement savings, from a net worth. You'd be surprised how much of a disparity often exists between two different spouses, especially if we have a spouse that's stay at home, that's got to go back to work. And I'm doing that to, again, prepare the professional team. I want to give as much information out to the attorneys so that we can facilitate the best possible, most appropriate outcome financially for our clients. I'll also create preliminary spousal maintenance and child support worksheets. And again, preliminary is the operative word. I'll underscore that. It's just to kick off the discussion so we can look at income and the other variables and child support calculation. There's an assessment of other financial resources at times, usually number one, EI, mortgage lender. I tend to reach out to them. I think many of the people in this discussion do, because we want to understand whether or not each client, whether they're refinancing, doing a cash out, or there's a new home purchase in the future. We'd like to know what type of income requirements can they pre-qualify, so we understand that going into discussions. The financial education piece is often, one of the spouses might say, you know what, I've got some concerns, some thoughts, there's some sensitivity around certain things. Can I just get a half hour of your time? Help me understand this a little bit more. I don't understand why we're dividing property potentially this way, and what assets would make the most sense for me. And so sometimes there's either a deeper discussion, and those can be one-offs. Sometimes there's a spouse that is really struggling a little bit with the numbers, and that's totally natural. And so I want to make sure that there's parity between the knowledge levels, that we're not going too fast, that each party, each spouse has a really firm understanding of what we're talking about and what those financial settlement options might look like. And then number three, especially the last year, a lot of my cases, I'm maybe jumping ahead a little bit and maybe working with the clients and modeling out a couple different financial settlement options so they can kind of understand that there are options, there's variety, that the process is pliable. And I like to be able to turn the case over and say, door number one and door number three seem to resonate with the party, and maybe that's where we start in our financial discussion. So I like to be able to do that. And as we get deeper into the discussion through the process, a lot of times another scenario might pop up where I'll create the scenario, look at the financial future, understand if that's a more appropriate financial settlement option for the client. Beth?
All right, thanks, Patrick.
You bet.
So we're moving to Janine, who's going to describe her role as a collaborative divorce facilitator and tell us a little bit about some of her experiences. And I don't think Janine needs the screen share.
I don't. So you can take that screen share, stop share there, Patrick. There we go. So I like to start
Sorry
this.
about that.
I'd like to start this discussion by acknowledging that a divorce has legal, financial, and emotional, relational, and sometimes parenting aspects. And by having a collaborative team, all of those aspects are supported. So emotions will drive the process if left unsupported. I think of it as a small rudder on a big ship. And so sometimes we try to minimize those, especially people that are on their own and without a collaborative team around them, but they do need to be addressed. So the CDF role does help with that. The CDF role also helps to facilitate the process by scheduling the meetings, by initiating agenda development. We do have an agenda for each of our meetings, by maintaining the agenda during the meetings to keep things on track and keep them moving forward. We recognize that we have a lot of professionals and the clients appreciate this, somebody dedicated to watching out for the time. CDFs take the lead in identifying the goals and interests like we just talked about, and then can also remind the team of these goals and interests throughout the process so that we're always focused on those. The CDF will work with parents to develop their parenting plan and also to help them prepare for co-parenting. And that can be trickier than we know. You guys probably know, but it's trickier than they know. So the Collaborative Divorce Facilitators have a wide variety of experience and skills. Some may be trained as mental health professionals, some as mediators or coaches, or a combination of these. And they may also have expertise relating to things like parenting or conflict coaching or relationship systems coaching, grief recovery, working with step families, and or communication, all of which contribute to this role. It is important to note that the CDF is not in a therapeutic role, even though some have the mental health background. The CDF is not offering therapy or counseling to either party. Usually parties are thrilled about that. I have my own therapist, thank you very much. So we don't come in that role, but we're instead working with the balances of relational balances and communication dynamics, as opposed to like diagnosing or labeling. In the big picture, a diagnosis is of little worth anyway, because we work with what shows up. Whatever a client presents, we work with that. So the CDF may meet with clients outside of the group meetings, just as Patrick was talking about for his financial neutral role, in order to help them with communication or relational sticking points, things that might prevent them from going forward, things that have hung up in their past. They need a little help sometimes with the relational dynamics they bring to the divorce, because they don't go away, they often are magnified, and this helps. So here's a little example of a case that I was on. Husband had a new girlfriend. He promised the wife that he would not introduce new girlfriend to the children, but lo and behold, wife came to husband's house and there was the girlfriend with the children. Naturally, she felt betrayed and lied to, and went and immediately withdrew a large sum of money from their joint bank account. So things were going downhill pretty fast. The whole case was threatening to collapse as they went downhill. And the team together decided that both neutrals would meet with these clients, in large part because on this particular team, we had a male and female neutrals. Patrick and I were on this case, and we met with the clients and we were able to help them understand the severity of their unilateral decisions and not keeping agreements, and to help them create new agreements, especially how it pertained to the children and potential partners and money. So without this intercession in this particular case, it was destined to go sideways, and we did get them divorced successfully. Okay, Beth.
All right, thank you, Janine.
Mm-hmm.
We're going to go back to Georgiana to talk about the role of the collaboratively trained attorney and how that might compare to the traditional role. And she's spoken a little bit about it, but can you add a little bit, Georgiana?
You're muted.
There we go. I would say the primary role of a collaboratively trained attorney is settlement. That should be their primary focus. The collaborative attorney has the same ethical duties as anyone else representing a party either as an unbundled representation or in litigation. All the same rules of professional conduct would apply. One of the primary considerations about collaborative is candor, not just to the tribunal, but also to the parties and professionals. This candor is required in both the settlement discussions and in disclosures, whether they're required under 16.2 or they're being sought as informal discovery. However, collaborative attorneys do provide confidential legal advice to their clients throughout the process. It does occasionally happen that a collaborative attorney would offer a settlement idea during a meeting that might potentially benefit not just their own client, but also the other client and the family. This, I think, is a striking difference from litigation. Collaborative attorneys and the neutrals need to have a very high level of trust in one another in order for them to practice effectively. That trust is then modeled to the parties, which in turn creates a less threatening environment for the parties. Collaborative does represent a pretty significant paradigm shift in the role of attorneys, especially as we compare it to the litigation model. We do know that these days, many attorneys are settlement-minded, and we invite any of those like-minded attorneys to join us in collaborative practice. True collaborative practice requires that all professionals be collaboratively trained. One question that we get a lot is, why do lawyers like collaborative practice? For myself, it allows me to have deeper, even friendships and relationships and trust with my colleagues and other collaboratively trained professionals. I appreciate, and so do the clients, not being on the court's timeline when the parties are efforting mightily to reach agreements that are going to guide the rest of their lives. I do enjoy working with parties to create creative and satisfactory agreements and watching people grow and flourish as the process unfolds. There is a huge burden lifted from counsel when litigation deadlines are not looming. Collaborative allows us to step out of strategic maneuvering, which is part of what we see in litigation. It allows us to avoid the cost of formal discovery, and does offer some leeway in how outside experts such as PREs and such as that are involved. The collaborative attorneys have to remember that their clients have at the outset signed a contract not only about disqualification, but also more importantly, or as importantly, that they will avoid court intervention to whatever extent they can. It's the role of the collaborative attorney to honor those clients' wishes and stay focused on resolution rather than ill will. Thanks, Beth.
Okay, thanks, Georgiana. Amy, do you have anything you want to add to that about your experience in the attorney role?
I would reiterate, I think it provides an opportunity for attorneys who are really skilled at, that their skill set lies in facilitating settlement. And that isn't the skill set of all attorneys, but to utilize those skills while also still in an advocate role as opposed to mediation. But
Good.
Thanks. So Amy, could you go on to explain a little bit about how the collaborative law process compares to mediation?
yeah, and I will share my screen. Let's see. So this is a diagram that I didn't develop, but I think it's from Janine, just going through a comparison of different dispute resolution processes. As an attorney mediator, clearly I think that, and a collaborative lawyer, I obviously think that mediation and collaborative law are, ideal for the purpose of resolving disputes in the family law context. I think that a distinction would be, there are some cases where having all the professionals involved throughout the process can be beneficial and really helpful. So essentially especially having attorneys involved from the outset. Sometimes there's circumstances where, having a little bit more client containment early on through the attorneys is going to be really beneficial to the process. And those might be the type of cases that might be more challenging as mediation, but with, some containment by the attorneys early on, they can benefit from the collaborative process. And another distinction and benefit would be, not having attorneys come in at the last minute, to sort of deconstruct agreements that clients have reached in a way that isn't constructive. And as Georgiana mentioned, also for attorneys, not having to anticipate and prepare for litigation in the event that mediation doesn't resolve the issues.
Thanks, Amy. And so the last part of the presentation is we're going to ask Georgiana just to let everyone know how they can, any professional can obtain collaborative law practice training. You're unmuted.
Sorry about that. Collaborative training can be had primarily through the Collaborative Divorce Professional Statewide Organization. Generally, level 1 collaborative trainings occur twice per year. The next level 1 collaborative training is in February of 2022. We don't have dates established for that as yet. A level 2 collaborative training is coming up in April of 2022. If you would like to learn more about collaborative trainings, you can go to the websites. Beth put those in chat for both the Front Range Collaborative Divorce and the Colorado Collaborative Statewide Organization. Or you can reach out to any member of the panel. There will be a slide at some point, I think, that has our contact information, or you can go to our Front Range Collaborative Divorce website and call any one of us. We appreciate you guys attending.
Yes, thanks, everyone. Maybe right now, Amy just could put up that slide, and the last slide with the contact information. And if it's there we go. And that'll be there. It'll be in the materials that you'll receive in the PowerPoint. What we're going to do now is move to the questions. And I see Brett asked a couple of questions, and I can read the questions, but Brett, if you want to unmute and talk about them further, I will address it to anyone on the panel who would like to answer. What would make a family a good candidate for collaborative divorce? And I think we can, okay, this will be in your PowerPoint. And now the panel, we can take down the screen. I think we can put it up at the end, but I think it would be good to have the screen.
Okay.
So everybody can talk with and take their turns answering.
The question again?
What would make a family a good candidate for collaborative divorce?
I think any family that, as I mentioned earlier, is concerned about their children. That's not to say that parties in litigation and other ADR processes aren't concerned about their children, but often what I see is parties coming in and are very, very focused on, we want to do what's best for the children, and a client saying, and I want to do what's best for my spouse. I want to know what they need. I want to make sure they get what they need, whether it's financial or emotional, educational, such as that. So I think we typically would expect or hope that parties would come in with a pretty high level of empathy for one another, able to walk in one another's shoes. That's not to say we don't do plenty of cases where we save the parties from themselves when they just don't really have that skill set.
Personally, I think almost any family can be helped, except for really high conflict cases. High conflict doesn't work at all.
Yes, and both parties are, really open to understanding what the universe of options are, as opposed to drawing hard lines in the sand. So they want to do what's right. They want to do it with dignity. They come with an open mind for the most part. And I think the collaborative process tends to kind of, I'll use the word, kind of certify that this is not going to get highly contentious, that we're going to continue down the path of dignity and respect. And I think that's the perfect candidate for collaborative.
They're drawn to the word collaborative. That's how
They are.
Yeah.
Yes.
Amy, do you have anything you want to add?
I was also just going to mention, I think in particular, a couple or family where, I was referencing mediation, but if you have a family that just feels that they need more support in terms of having attorney representation, that's going to be helpful. That would be a family that, would be appropriate for collaborative.
So, Brett, I'm hoping that answered your question. I do want to move on to your next question.
It did.
Okay.
Yeah, it did more or less. I mean, I see a lot of high conflict cases, but certain things, like it sounds like people who maybe have, drug issues or other substance abuse issues might not be good candidates for this unless they have a high level of self-awareness
Right.
about those issues. Things like that would kind of maybe screen people one way or another that they're likely to be successful in this process, I guess.
Yeah, they have to be able to be collaborative.
Yeah, which is key.
Right.
Yeah, it's definitely a competence issue. And that applies for mediation as well, for what's going to work. When is that going to work well? But in a case where there might be some substance abuse, perhaps having the extra support could make it better for a person, or a family better for collaborative than for mediation, by having that extra support, maybe bringing in some other experts. But that might lead to the next question, which was, what are typical costs for the collaborative divorce? Is there a way to adapt this process for low-income families? So Patrick, do you want to lead with this, or anybody else want to take that on first?
Yeah, I'll say a few things, and I think the attorneys can speak to this better than I can, because I don't see, the other side, which is what's the cost of litigating. And I have to say, based on my experience, that I think the cost of litigating is almost always going to be more than a collaborative case. Yeah, so it varies, and you can't put a hard number on it. And and I'll say that a lot of that cost containment, cost management, is really in the lap of the client, believe it or not. Are they doing their homework? Are they getting the financial disclosures together? Are they coming prepared to the meetings? Are they doing some behind the scenes communication and collaboration? I mean, there's a lot that can get accomplished before we do a 3-way, a 4-way, or a 6-way. And so I think a lot of that, in my experience, is up to the client, and it's somewhat up to the complexity of the case, which I'm stating the obvious. Georgiana, do you have something to add to that?
Well, say a couple of things. One is, I know that there are members of the collaborative community that are working on a model for low-income families and for low-cost collaborative. I'm not aware as yet what that status is, but that's certainly something we can talk with about the board. We meet next week, and I could get back to you with any kind of information we have about that low-income process. But the cost of collaborative, I would say, in my experience, is generally lower than the cost of a litigation. Certainly everything Patrick has said is correct, that to the extent that the clients sort of drive the process, they can also drive it into the ground, both financially and on every other level. And as to cost, I've had collaborative cases where we wrapped everything up in 3 months. And of course, the shorter the time period, naturally, less expensive it's going to be. And we've had collaborative cases that have gone on 4 months for a variety of reasons, some good and some sad. But the costs, it's very, very hard to, until we come up with this low income process, which I understood at one point was going to be sort of a fixed fee, at least on the part of the professionals. I think it's really hard, and I'm sorry, because I know in your job in particular, we would like to know, right, what low-income families need and what they can have. But I don't know that we can say very clearly what a typical cost for collaborative divorce. That's such a lawyer answer. Sorry.
Well, one thing that's important, I think, to point out is that each professional is charging separately. So the collaborative divorce facilitator will have whatever their fee is. The financial neutral will have their fee, and the attorneys will have their fees. but there may be ways to work with those professionals to help keep the costs down. And the time is managed so that they're not always meeting with all the professionals. Try to do as much with the financial neutral separately and the collaborative divorce facilitator separately to keep those costs down.
And I would love to be connected with whoever's working on the low income option, just because obviously very relevant to my work. And I do meet a lot of people who can't afford one attorney, but I think would flourish in this type of situation. So seems, if there is ever an option for it, a great resource for those families and a great outcome for those kids.
I'll check that out with CCDP
Yeah.
and contact you, give you whatever information we
Oh,
have.
cool. Thank you so much.
Sometimes when we're screening clients for the collaborative process, we also take into consideration what will happen to this family if we don't take them on in the collaborative process. Right? If we leave them to themselves. Georgiana spoke to that a little bit. So we do consider that.
So it's looking at the non-financial costs as well of the whole
Yeah.
process.
Right. Yeah, there's a lot of added benefit to working in a collaborative case. Georgiana spoke to modeling. We also model, the collaborative professionals model for the clients how to be collaborative and how to work together collaboratively. So when their case is over, they can be better co-parents, and other things as well.
So those were the questions in chat. Does anyone else have a question right now?
Janine, do you have
Panelists
any
is-
thoughts about how the statute's going to impact your practice, if at all? I mean, these new requirements about informed consent and certifying that, or taking reasonable efforts to ensure that there isn't domestic violence or coercion going on. They're newer. I'm assuming those are new requirements that collaborative lawyers didn't have before, at least in a requirement under statute. So, but other than that, is there any other ways that you see the statute having an impact?
I'll just say that a couple of things. We have been sorting clients, people who come in on this DV and coercion for the entire time that collaborative's been around. Only because, just like mediation, if there's a power imbalance or something like that, then the clients are clearly not going to be able to be in the same room or be able to function adequately in a collaborative process. So fortunately, although it's codified in the statute, and that's great, there has been a lot of talk in the collaborative community and in trainings about how to select out folks that just have those kinds of issues. And the informed consent, it's an interesting question because it's in the statute now, which is great. But if you read which I don't expect you to, the participation agreement and the associated document called Principles and Guidelines, more about that later perhaps, but we do have a lot of language about informed consent that I would qualify as informed consent. But it still behooves the collaborative lawyer to have that very direct conversation with a client, just as Janine said earlier, so that we can be assured that the client knows exactly what they're getting into. We certainly had cases where folks came in and the expectations were slightly different, I think, than what was being offered. And that created some problems with communication and moving the process forward while we were trying to continue to instruct those clients. So I appreciate your question. And yeah, I don't know how much that's going to really change the practice, but I think it's going to remind everyone, don't forget informed consent. It's such a critical piece.
Thank you.
And maybe this is obvious, but it seems like now that we have this, it is more attorneys are willing to come along and practice collaboratively because we didn't have this before. And so people were kind of afraid of it or concerned about it, maybe is the better term.
Yeah.
And that would be good for our group as well. So we do hope that some people who are watching now or watching later will decide to get that training and be part of the group. So there's more choice for the clients.
We need collaborative lawyers. A bunch of the collaborative lawyers in Boulder County just retired. So we're looking for professionals for sure.
Come play.
Yeah.
So unless there are any other questions, I think we can end the program tonight, but any of us on the panel will welcome questions. And maybe, I don't know, Amy, if you could put up the slide one more time, but it will go out to everyone with our information and the presentation, which Amy did such a nice job summarizing the act. And so you get to see benefit from her summary. So.
Yeah.
Our information will be there and you can contact any of us if you have any questions.
Right.
Thank you, panel.
Thank you.
Thank
Yes.
you so much. This is wonderful.
Oh, good.
Nice.
Thanks,
Yeah.
everybody. Nice to see you all. Appreciate the update. Very well done.
Thanks, Steve. Good to see you. And I guess I know that Kyle was recording us and I guess he'll start ending the recording in a minute.
And I will get the PowerPoint and the CLE format to everyone by tomorrow morning at the latest. And if you have any questions, you can contact me. But thank you everyone for participating and thank you for presenting.
Thank
Have a good
you.
evening.
Okay, thank you.
Bye.
I know.
Bye.